assignment. Our group number is group 2, and these are my teammates, Hani, Kritika, Vidaya, Devadashini, Umaira. These are the table of contents. We have the offer proposal until the acceptance, revocation of offer.
Okay, offer proposal. The definition of offer proposal. An offer proposal in contract law is a clear and definite proposal made by one party, the offerer, to another offeree, indicating a willingness to enter into a binding agreement on specific terms. The offer outlines the agreement existing terms and one accepted by the offeree forms the basis of legally enforceable contract. Elements of offer proposal in contract law. First is intention to create legal relation. The offerer must intend to create a legal obligation upon acceptance by the offeree. This means the offer must be made with the intent that it will become binding once accepted. The case law, Carly v. Carbonic Smoke Ball, Coco. 1893 1 QB 256. The court held that the advertisement for the smoke ball was an offer because it demonstrated a clear intention to be bound by offering a 100 euros reward for anyone who used the product and still contracted influenza. The company deposit of 1,000 euros in the bank, showing its intention to be legally bound. The second one is distinction from an invitation to treat. An offer must be distinguished from an invitation to trade, which merely invites others to make offer. The case law is Fisher v. Bell, 1961 1 QB 394. Displaying a flick knife in a shop window was held to be invitation to trade, not an offer for sale. Therefore, the shopkeeper was not liable under the Offensive Weapons Act. Example of offer proposal. First is real estate offer. An offer to buy a house for 250,000 with a closing date of 30 days. Includes terms like the deposit amount, inspection period, and contingencies. Example, obtaining financing. The second one is employment offer. A job offer specifying to the position, salary, benefits, start date, and the work location. Then outlines probation period, job responsibility, and reporting hierarchy. Thank you.
Offer proposal, communication of offer. An introduction to contract laws, definite terms. When an offer is said to be clearly in contract law, it means that the terms must be correct, understandable, and able to be accepted by the offeree without the need for additional discussion or clarifications. When two parties enter into a contract, this principle makes sure that they are both aware of their rights and obligations. Case example, Carly v. Carbolic Smoke Ball Co. 1893. The Carbolic Smoke Ball Co. advertised in 1893 saying their product could stave off the influenza. The advertisement also promised 100 euro in compensation from the company to any customer who used the product as instructed but still got influenza. Question. The main question was whether this advertisement created a legally enforceable agreement between the business and prospective clients who used the smoke ball as instructor but still contracted the flu. Judgment. According to the court decision, the advertisement constitutes a unilateral offer that could be accepted by any party, providing the required conditions were met. The advertisement made it apparent that the company intended to be legally bound by its offer due to its clarity and specificity. Miss Carly was therefore eligible to receive the €100 reward in accordance with the terms specified, given that she had used the smoke ball as instructor and subsequently developed influenza. Thank you.
Also, revocation of offer. Revocation is a cancellation or withdrawal of an absent is a contract law before the official formation or completion of the contract. In simple terms, revocation allows one party to opt for a proposal contract before it becomes legal binding. Revocation offer versus revocation of absent. While revocation is both withdrawal of an offer and the withdrawal of an absent, there are some key difference in their legal implication of requirement. It is easier to understand this insisted for efficient management of contraction. For example, assume person A offered to sell their car to person B. Person A can revoke their offer if person B accepts it yet. However, if person B accepts the offer but later discover a hidden difference, they might to revoke their accept if they communicate this discovery to person A before and release on the absent and before any performance of the contract. Thank you.
Acceptance of counteroffer. So a definition of this term is an accepted counteroffer is in which the term of the last offer are modified or changed. A counteroffer rejects the previous offer and generates a new offer. As a result, by making a new offer, the original offeree becomes the new offerer, and the new offeree can agree or reject the new modified offer. An example, let's just say you want to buy a second-hand car from Kaish. So Kaish offers to sell you a car for $10,000. You might find the price too high or want to reduce the price. So you would say you want to buy the car for $9,000. This is a reaction of counteroffer which effectively rejects the first offer. Kaish then accepts your offer of $9,000 for the car. Kai's response is an acceptance of the counteroffer, creating a binding contract of $9,000. A case example is Hyde versus Ranch 1840s. Mr. Ranch, a definite initially offered to sell his farm to Mr. Hyde for $1,200, but Hyde declined. He later offered $1,000, and he was clear that the offer was his last offer. In response, Mr. Hyde offered $950 for the farm in his letter, which Ranch refused. Hyde then, after agreed to buy the farm for $1,000, which was the previous offer. However, Ranch refused to sell his farm to him. In conclusion, acceptance of counteroffer requires terminating the original offer and creating a new term presented by the original offeree. To create a valid agreement, the original offerer must accept these new terms. Thank you.
Communication of acceptance. Mode of acceptance. In this case of communication acceptance, there are two factors to consider: the mode of acceptance and then the timing of it. Let us first talk about the mode of acceptance. Acceptance can be done in two ways. Communication of acceptance by an act. This would include communications via words, whether oral or written. So this will include communication via telephone calls, letters, email, telegraphs, and etc. Communications of acceptance by conduct. The offeree can also convey his acceptance of the offer through some action of his or by his conduct. So say when you board a bus, you're accepting to pay the bus fare via your conduct. Thank you.
Acceptance, reservation of acceptance. Timing is crucial. The reservation must be communicated of the offeree before they accept the offer. Once the offeree accepts, the offer cannot be taken back. Communication matters. The offeree needs to receive the notice of reservation. It's not enough for the offeror to simply decide to cancel the offer without telling the other party. Exceptions exist. There can be exceptions to this rule, such as option contracts, where the offeree pays something valuable in exchange for the offerer keeping the offer open for the certain period. Thank you.